The first question in 2025 prelims in subject of polity was on topic of ordinance. Now ordinance is law made by executive, that is president or governor. Now in Constitution of India, the word ordinance is not defined, but it has been mentioned under part 5th and part 6th. The article 123 provides for legislative power of the president, and the article 213 under part 6 provides for legislative power of governor. Now this ordinance making power has been borrowed from Government of India Act 1935. Such power has been provided so that president or the governor can deal with unforeseen, urgent or exigencies when the parliament or the state legislature are not in the session. Next, we need to see that when this ordinance making power can be exercised. Now, president can promulgate ordinances during recess. Now we need to see the meaning of word recess. Recess is duration between two sessions of parliament. For example, budget session ends in May and the monsoon session begins in July. So, the month of June is here recess. Now, when can this ordinance be promulgated? There are two situations. Firstly, when both the houses are not in session, or when even one of the houses is not in the session. Now, the reason is the law can be made only when the bill is passed by both the house. So even if one house is in session but it cannot pass the bill and law cannot be made, so even if one house is in session, still ordinance can be promulgated. So the ordinance cannot be promulgated when both the houses are in session. It means that the ordinance making power is not parallel with the legislative power of parliament. So, the ordinance making power of president is coextensive with respect to parliament's legislative power. Now, this we need to understand. Coextensive means ordinance making power is same or having similar attributes as legislative power of parliament. Like, ordinance can be made on same subject matters as provided under Schedule 7, Union List and Concurrent List. Further, ordinance has similar restrictions as legislative power of Parliament. Next, we need to see who has this ordinance making power. So we have already seen that executive at union level, president, and at state level, governor has this ordinance making power. Now, president or governor can make ordinance only when they are satisfied that such circumstances exist which require them to take immediate actions. Now, this satisfaction is not discretionary. This satisfaction is actually based on aid and advice of Council of Ministers, which is headed by Prime Minister. So we know that President does not have constitutional discretions. President has to take actions or function based on aid and advice of Council of Ministers as it is provided under Article 74. Further, this satisfaction can be questioned in the court. It means that the satisfaction of president or governor can be subject to judicial review. That is, court can check whether the satisfaction was based on genuine reason or was it based on some corrupt or malintentions. For example, in Bihar, there were incidents where the assembly was prorogued continuously so that ordinance can be made by the governor. To check such incidents, Supreme Court under Cooper case provided that satisfaction is subject to judicial review. After that, Constitution amendment was made under 38th Constitutional Amendment that provided for satisfaction is final and conclusive and beyond judicial review. This was during emergency time, but this was later on deleted by 44th Constitutional Amendment as it has been provided under Keshav Nanda Bharti case 1976 that judicial review is basic structure. Next, we need to see what kind of effect this ordinance has. Now we have already seen that ordinance making power is coextensive with the legislative power of the Parliament. So the ordinance promulgated has same force and effect as Act of Parliament. Now, whenever law is made, its effect can be prospective, that is having effect after the law has been made, or retrospective, that is, it can have effect from backdate, or again it can amend tax laws. So all these properties which an act of parliament can cause, similarly ordinance can make these effects. But there is difference that an act of parliament can, under article 368, make amendment to the constitution, but ordinance cannot amend the constitution. Further, as act of the parliament cannot abridge, that is, take away fundamental right under part 3 of the constitution, in similar way ordinance cannot abridge fundamental rights. Further, this has been provided under article 13, where it has been stated that state cannot make such laws which take away or abridge fundamental rights. Now, here the law includes ordinance. So, ordinance cannot take away fundamental rights. Next, ordinance cannot make such laws which Parliament itself cannot make. And if any such law has been made by ordinance, it will be void, means having no effect. Next, we need to understand how long this ordinance continues to exist, when does it cease to operate, and how it continues or how it ceases to operate. Now, the ordinance has to be approved by passing of resolution by both the houses on reassembly of the parliament. This is because the legislative power is actually function of parliament and not executive. So the ordinance has to be approved by parliament within period of 6 weeks. If within 6 weeks resolution is not passed, then the ordinance ceases to operate. There is another route through which ordinance can cease to operate. It is by withdrawal by the president. Now here again, the withdrawal is not on discretion of the president but on aid and advice of the Council of Ministers, and this withdrawal is notified in the Gazette of India. Now, when it comes to continuance of ordinance, it has to be passed by resolution has to be passed by the parliament, and for maximum period to which it can continue without being passed is 6 months and 6 weeks. Now here this maximum period is because in the constitution it has been provided that between two sessions of house, the maximum duration can be of 6 months. So the parliament has to be assembled after maximum period of 6 months, and then resolution has to be passed within 6 weeks. Next, we need to see the issue of repromulgation. Here the name of the case is important, Vadhva case, in which the Supreme Court said that repeated repromulgation of ordinance without any change in text and without making any attempt to get the ordinance passed as bill leads to fraud on the constitution, and such repromulgated ordinance can be struck down. Further, in another case, Krishna Kumar case 2017, Supreme Court has mentioned that ordinance making power is not absolute and it is subject to test of necessity and immediacy. That is, it is not immune from judicial scrutiny. Now, these judgments have been given in context of Ordinance Raj, that is, overuse of ordinance making power to bypass parliamentary scrutiny. So, normally the law has to be made after debate and discussion in both the houses, in which opposition gets equal opportunity to raise concerns. But ordinance bypasses all this process and leads to what is known as executive overreach, where executive is performing the legislative work of parliament. Finally, we need to see the ordinance making power of the governor under Article 213, which is similar to the ordinance making power of the president except for few changes. Now again, the governor can promulgate ordinance during recess of the legislature. Now here we need to understand a small difference, that most of the states in India have only one house, that is State Legislative Assembly. Only 6 states have 2 house, Legislative Assembly and Legislative Council. So in case of states that are having 2 houses, the process is similar to the parliament, where both the houses need not to be in session so that governor can promulgate the ordinance. Now the difference between the ordinance making power of the governor and the president is that in some cases governor has to take instructions from the president to make ordinance on those subjects, such as bills which require prior sanctions of the president or which need them to be reserved by the governor for consideration of the president, or which needs assent of the president. Another unique point regarding the ordinance making power of the governor is with respect to the ordinance making in the concurrent list. Now, before understanding that, we need to understand the legislative power of state assembly with respect to concurrent list. So, laws made by state legislature on concurrent list subjects become invalid if they are not in consistency with the parliamentary laws. But if these laws are given assent by the president, then they prevail over parliamentary laws. Similarly, in case of ordinance, in concurrent list, when the ordinance is promulgated which are in repugnant, that is inconsistency or not in consonance with parliament laws, they become invalid. But if these ordinances are promulgated after following the instructions of the president, they remain valid and will be considered as to be reserved for the consideration of the president and given assent by him. That's all for the topic of ordinance for prelims. Thank you.